court is making a determination is in respect to a miscellaneous application seeking the respondent pre-charge detention. There is no criminal trial yet. This follows the abominable, macabre murder of a teacher and blogger Albert Omondi Ojwang hereinafter the decease that took place on the 8th day of June 2025, allegedly at the Central Police Station, Nairobi. While coming up with this ruling, a stone throw away from here, this country was confronted with execrable and reprehensible scenes following the Margon protest that took place yesterday on the 17th day of June 2025, paradoxically, to condemn the murder of the deceased. I point out and I shudder for my fatherland, and if I can borrow from William Shakespeare's poem, The Rape of Lucrece, I'm terribly in terror following the degeneration of lawlessness that was witnessed yesterday. I fervently take this opportunity to remind my beloved countrymen of the Israel World Holocaust Remembrance Center and the Kigali Genocide Memorial. Let us all collectively proclaim never again. Now to the body of the application. So the applicant, by way of notice of motion dated the 16th day of June 2025, has moved this court under the provisions of Article 49, Sub-Article 1, Paragraph F, G, and H of the Constitution, Section 36, uppercase A of the Criminal Procedure Code, Section 6A, 71A, and G of the Independent Policing Oversight Authority Act, and Regulation 7, Sub-Regulation 4 of the Independent Policing Oversight Authority General Regulations 2024, and all the enabling provisions of the law. The applicant now seeks to have this court have the respondent to be remanded in Lang'ata Police Station or any other police station within the Republic of Kenya as the investigation may dictate, to enable the applicant to conclude the investigation for a period of 21 days. The other prayer seeking to have the respondent's gadgets seized and subjected to forensic examination was conceded to. The applicant has on the face of the motion explicated the following grounds in support of the prayers. A, that the applicant is conducting investigation by inquiry number IPOA/INV/476/2025 into the gruesome murder of the deceased that is suspected to have occurred at the Central Police Station, Nairobi, where the deceased was being detained. B, that the respondent was arrested on the 30th day of June 2025 by the DCI officers and subsequently handed over to IPOA and was later booked at Lang'ata Police Station by OB number 50 of 13th day of June 2025 at 18:05 hours. C, that at the time of the respondent's arrest, he was duly informed the reason of his arrest, which is the ongoing investigation on the gruesome murder of the deceased. That brief evidence gathered so far, the respondent and others still at large are suspected to have directed, planned, and attempted cover-up of the brutal fatal assault of the deceased while inside the cells at the Central Police Station, Nairobi. E, that at the time of the respondents, his mobile phones were seized and are yet to be subjected to forensic examination. F, that from the time the respondent was arrested, the time within which to complete investigation has not been adequate, and there is need for extension of time to enable completion of investigation. That based on the ongoing investigation, the applicant requires additional 21 days within which to complete investigation, and that the respondent be detained at the aforementioned police station. The application is supported by the affidavit sworn by Abdirahman Jibril, a Senior Assistant Director of Investigation with the Independent Policing Oversight Authority. Here, after I'll refer to as IPOA, on the 16th day of June 2025. He deposes inter alia that preliminary investigation by IPOA has revealed that on the 4th day of June 2025, the Directorate of Criminal Investigation received a complaint from the Deputy Inspector General of Police, Mr. Eli Legat, alleging that he suffered continued false and malicious publication on an X account, formerly Twitter, with the name Pixel Pioneer, and requested investigation as to the perpetrators. He contended that following investigation, it was established that the deceased, a resident of Lira Center within Homa Bay County, was identified as a person of interest. He further avowed that the deceased was arrested and escorted to Nairobi, where he was booked at Central Police Station by OB number 136 of the 7th day of June 2025 at 9:32 p.m. while appearing normal. He also deposed that at the material time, the respondent was the officer commanding police station, exercising command over the Central Police Division, thereby wielding immense powers with the capacity of interfering with the ongoing investigation and witnesses. He attested that the respondent is the custodian of the station records and the surveillance system, which is likely to interfere, and further that the respondent and the co-conspirator allegedly hired a technician to interfere with the CCTV system at the station in a bid to tamper and interfere with the investigation. He asserted that on the night of 8th June 2025, the deceased was found unresponsive in a pool of blood inside the cell and was taken to Baghdadi Hospital, where he was confirmed already dead, and subsequently a postmortem revealed that the cause of death was head injury due to blunt force trauma, neck compression, and multiple subcutaneous bruises all over his body. He contended that the respondent with other persons at the station were instructed he contended that the respondent with other persons at the station were instructed and caused to make false entries in the police records with a view of misleading the investigations. He further averred that the respondent was in constant communication with one James Mukwana, the cell sentry personnel on duty, and who had access to the cells where the deceased was detained. He also contended that the respondent has had constant communication with people within and outside Central Police Station immediately before, during, and after the commission of the crime, and therefore suspected to have planned the brutal assault of the deceased. He contended that the release of the respondent will jeopardize the arrest of his accomplices involved in this gruesome murder, including witness interference, who are under the command of the respondent. He urged that the key figures targeted in this investigation are police officers who wield powers and influence and have engaged in a complex web of cover-up employing the blue code of silence. Thus, the need to detain the respondent to impede interference with investigations and witnesses. It was also his consternation that the murder of the deceased has elicited widespread public anger and outrage, resulting to demonstration and a consequence, the safety, and as a consequence, the safety and security of the respondent cannot be guaranteed if released. In summation, he avowed that considering the seriousness of the offense, there is a temptation of the respondent fleeing the jurisdiction of this country, and therefore he is a flight risk. The application has been strenuously and vigorously backed by a battery of indefatigable counsel representing the respondents. They are, in order of seniority, Mr. Danstan Omar, Mr. Cliff Mbetter, Mr. Shadrack Wamboi, Mr. Kanai, Mr. Stanley Kinyanjui, Mr. Udoto, Mr. Langat, Mr. Keaton, and Ms. Sophia Nekesa. I hope I have not left anyone out. Conversely, the applicant is represented by the lettered and studious counsel, Ms. Nora, Mr. Witty, Ms. Makori, and Ms. Christine Owino represent the IPOA, and the family is represented by the learning counsel, Mr. Julius Juma. During cross-examination by the respondent's counsel, the irascible deponent affirmed that IPOA has the powers to investigate deaths in the custody of police officers. He stated that the respondent recorded a statement upon his arrest. He confirmed that the respondent voluntarily presented himself at the DCI headquarters and that it was untrue that he was arrested in Eldoret. He admitted that he has not averred that the respondent was on duty at the material time. He also iterated that the scene is the Central Police Station, Nairobi, which has already been processed by IPOA. He affirmed that they are yet to record statements from certain critical witnesses, some of whom are police officers. He conceded that he has not provided several evidentiary material in support of his deposition so as not to compromise with the investigation. So additionally, the application was conversed orally. It will be remiss not to applaud the counsel for their punctilious, industry and erudite submission. have carefully and conscientiously considered the oral representations of the party's advocates, the constitutional and statutory authorities cited, as well as decisional law quoted in extenso, the jurisprudential underpinning on pre-charge detention, or what the Constitution in Article 49, Subarticle 1, Paragraph G delineates as detention continuing, as aptly pointed out by the Learned Counsel Mr. Witi, is now well settled. I am grateful to the Learned Counsel Mr. Ombeta, Mr. Keaton et al. In having a footprint in the development of the law in this realm, in some of the authorities that the Superior Court, which has been cited herein. Mr. Witi, Learned Counsel, on behalf of the applicant, has anchored the application on Article 24, 25, 29, 49 of the Constitution and Section 36, uppercase A of the Criminal Procedure Code, as well as Section 8, subsection 2 of the Magistrate Court Act, and the seminal and the well-crafted and the grandiloquent decision in the case of Sudi Oscar Kichumba versus Republic 2020 EKLR. He made reference to paragraph 24 of the ruling, where the learned Professor Ngugi J, as he was then held, open quote, so even while accepting the text of Article 49(1)(f), may in certain circumstances and context comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reason for his continued detention through the state's application to have him so held. The state must satisfy the double test. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without charge, being preferred whether provisional or otherwise, is inevitable due to existing exceptional circumstances. The second test is the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial, the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interests of the victims of crime where appropriate. By virtue of Article 21(1) and 259 of the Constitution, the court must act to aggrandize, not to diminish, the personal liberties of arrested individuals in line with the other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by this quadruple interest and without reifying or essentializing any. End of quote. Flowing from the foregoing, he submitted that the respondent was duly informed of the reason for his detention and the state has acted in absolute good faith in timelessly presenting the respondent before court, and furthermore, that they have demonstrated that the balancing of the rights of the respondent vis-a-vis the victim, the interests of justice, public order, peace, security, and the integrity of the administration of justice. The Learned Counsel, Father Mr. Witi, in rejoinder to the submission, has appealed to the court to take public notoriety as to the seriousness of this offense. He ingeminated that the respondent, being the officer commanding station at the station, has immense influence on witnesses and investigation. Mr. Witi elucidated the phenomenon coined as the Blue Code of Silence by citing the Court of Appeal decision of Titus Gamao Musila Kakitu versus Republic 2020 EKLR, where counsel submitted that the court demonstrated and observed that the police officers in Kenya have in certain circumstances engaged in the practice of collective covering up for each other for purposes of self-preservation, patently in a murder investigation like the instant case. In its part, Mr. Makori, Learned Counsel, elucidated and annotated the averments in the supporting affidavit, emphasizing the possibility of the respondent interfering with witnesses and investigation as the officer commanding the Central Police Station. He entreated the court to grant the 21 days detention continuing order sought. Mr. Kitot, Learned Counsel for the respondent, made resplendent and methodical submission. He urged in general that the applicant have not demonstrated compelling reasons necessitating the continued detention of the respondent. He cited Article 49, sub-article 1 G and H of the Constitution, and section 36A3D of the Criminal Procedure Code. He added that there are no cogent and demonstrable grounds that the respondent will interfere with the investigation. He also cited the case of Republic versus Mercy Chebet, and also the case of Republic versus William Chirchir and another, where he submitted that the Superior Court held that there must be cogent material before court to demonstrate actual or perceived interference with witnesses by the respondents, which was lacking in the instant case. Mr. Keaton further urged that in limiting the fundamental freedom of a suspect, courts ought to be extra vigilant in granting such orders. He referred to the case of Ramadan M. Hassan versus DPP 2017 EKLR. He proffered further that the respondent has all along cooperated with the investigation. He reverberated that the respondent voluntarily presented himself to IPOA, where he recorded a statement and later presented himself to the DCI headquarters. He told the court that the respondent has since been interdicted and therefore has lost police powers to interfere with the witnesses. Furthermore, his interdiction has set condition that he should periodically report to the Eldoret police station. He urged the court to issue order that will be beneficial and less restrictive to the respondent. He made reference to the often cited case of Michael Rotich versus Republic by Justice Kimaru as he was then, 2016 EKLR, where the court stressed the need to protect and respect the right to liberty. Learned counsel adjured that the accused is not a flight risk. He submitted that he has a fixed abode both here in Nairobi and in Eldoret, and also that the respondent should be accorded the presumption of innocence. Finally, he urged the court to adopt the test of determining compelling reason as set out in the case of Republic versus Danford Kabage Mwangi, 2016 EKLR. He thus exhorted that the application should be declined. Mr. Langat, learned counsel, also for the respondent, iterated that there is no evidence of interference of the investigation. This the deponent confirmed that the investigating officer confirmed that they are in possession of the respondent's mobile phone, in which the respondent has control with regards to the forensic analysis. He submitted that the respondent is willing and ready to abide by all the conditions that the court will set. On his part, Mr. Kanai, learned counsel, also for the respondent, in reiterating that the respondent versus Richard David Alden, criminal case number 48 of 2016. He urged the court to invoke Article 19, 20, 22, 23, and 29 of the Constitution. He finally submitted that there had been no attempt by the respondent to abscond and therefore is not a flight risk. Juxtaposing the applicable test set herein above in this ruling as to whether the applicant has proved compelling reason, there are four broad reasons that have been advanced by the prosecution as compelling reasons. So I've distilled the first one to be flight risk, the second to be safety of the respondent and public order, the third one to be the seriousness of the offense, and lastly, interference with the investigation and witnesses. So on the first limp, on the seriousness of the offense, it cannot be underscored the fact that the charges that the respondent is being investigated on is grave and weighty. The seriousness of offense in terms of the sentence likely to follow a conviction has been held repeatedly to be a consideration in exercising discretion. The seriousness of offense has a clear bearing which the court ought to bear in mind on the factors influence the mind of the accused or the respondent facing a charge in respect to the offense as to whether it could be a good thing to skip or not. And such a possibility is not out of question. It has happened before and in similar cases. So I cited the case of Watoro versus Republic 1991, KLR 220. I will not wish to belabor into the propriety of this limit, basically because standing on its own, it cannot be a ground to denying bail or bond, but ought to be fortified and underpinned by other factors. That was stated in the case of Republic versus Zakaria Okoto Bado, 2018 EKR. Similar in the case of R versus Salim Said Nasoro and two others, High Court at Nairobi miscellaneous application number 35226, where the court again held that the seriousness of the offense per se is not a basis for denying bail. Additionally, in the case of Republic versus Sabit, Mamor Deng and another, 2020 EKLR, I'll not go into the cannot cite it. Consequently, let me just cite it. Okay. It's a short one. So additionally, in the case of Republic versus Sabbath, Mamor Deng and another 20 EKLR, the Supreme Court held and the court. However, in the current constitutional order, murder is an offense like any other for the purposes of bail pending trial, and therefore, a bail application in a murder case, as in any other case, has to be looked at from the prism of Article 49(1)(h) of the Constitution. And the key question that takes center stage is whether the accused will turn up for his trial if released on bond. End of quote. Consequently, in the premise, the fact only that the respondent will be likely to face serious charges is no reason to denying bond or bail. Courts have adopted innovative mechanisms and processes that ensure the accused person or respondent granted bail do not abscond. I'll go to the next link on flight risk. Intertwined with the above is on the likelihood of the respondent absconding. The paramountcy when deciding the issue of bond or bail is whether the respondent will attend trial or whether there is a likelihood of absconding. It is the rule of thumb and compass that should guide courts. This has been held in a host of cases. I've cited Job Kenyanya Musoni versus Republic, High Court, Nairobi, Criminal Application number 299 of 2012. It has been deposed that there is a high likelihood of the respondent absconding, considering the seriousness of the offense that is likely to be charged with. The foregoing ought to be deduced from the respondent's conduct before his arrest. It is indubitable that the respondent voluntarily presented himself to the DCI headquarters and IPOA offices. It was confirmed that the respondent was not arrested in Eldoret as earlier reported in the media. It has also not been controverted that the accused does not have a fixed place of abode and he has no familial ties. It was also considered by the deponent and the investigating officer that there was no presentation of material evidence to support this ground. Thus, an evidential fact that the respondent did not take any step to flee the country or circumvent arrest. Real evidence is required to show that the accused is likely to go into hiding and is likely to abscond. No such evidence upon which an inference may be drawn that he will abscond was presented. For that reason, this ground is not sustainable and I reject it. On the third limb, on the safety of the respondent and public order, on this prong, the deponent has averred that the gruesome murder of the deceased has elicited widespread anger and outrage, leading to demonstration which has been destructive, and therefore the safety and security of the respondent cannot be granted. Mr. Kiton, in opposing the application on this facet, has cited the case of Mercy Chebet, Super, where Gikenyi J has strongly vocalized himself in no uncertain term that at this time and age, such grant cannot meet the threshold of compelling reasons. The judge goes further to correctly state that it is the duty of the state to provide safety and security to its citizens. This position find fortification in the case of Republic vs. Mjirwa, criminal case number E001 of 2024, where the same learned judge, Justice Gikone, that is, espoused, I open quote, this court's view is that the ground that the security of the accused is threatened by the members of the public or family of the deceased should never be encouraged as a ground for denial of bail, unless there is real evidence of actual threat, lest we should inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. End of quote. Flowing from the foregoing authorities, I therefore find the argument that the respondent be detained for his own safety and security without real evidence to be succor is without legal and factual basis. In fact, to address the other tenant, I take judicial notice that demonstration and protest has been ongoing despite the fact that the respondent is in custody. On the last limb, on the interference with witnesses and investigation, the prosecution alleges likelihood of interference with prosecution witnesses and investigation. This is the most potent ground. Is the prosecution's allegation of likelihood of interference with prosecution witnesses as such amounts to an affront to the administration of justice, thus a justifiable reason to limit right to liberty. In also an often cited case of R versus Jackson Mayende and three others, it was stated, open quote, in all civilized systems of court, interference with witnesses is a highly potent ground on which the accused person may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general, as envisioned by the people of Kenya in the preamble of the Constitution of Kenya 2010. Threats or improper approaches to witnesses, although not visibly manifest as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses, an impediment to or perversion of the course of justice. If the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused. End of quote. I've also cited the case of R versus Patience Gishobi that uh, affirmed that the proven interference with witnesses is an affront to the administration of justice and therefore a compelling reason as contemplated by Article 49, Sub-Article 1H of the Constitution. Accordingly, the specific instances of or likelihood of interference with witnesses must be laid before the court with such succinct detail or evidence in support thereof as to persuade the court to deny the respondent bond on this ground. It was initiated in the case of R versus Dwight Surgery, I've quoted here earlier, Supra, and I quote, for the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of threat or threats to witnesses, direct or indirect, incriminating communication between the accused and the witnesses, close familiar relationship between the accused and the witnesses, among others. End of quote. It is therefore incumbent that the prosecution needed to demonstrate with tangible evidence of the actual interference or likelihood of interference. I've said the case of Richard David Allen, already cited. The court must therefore strike a perfect balance to ensure that the trial is not impeded by acts of interference with witnesses, but at the same time uphold the rights of the respondent. This was held in KKK versus Republic 2017 EKLR. The common ground in the Easter case is as follows: is that the respondent is the officer commanding police station, Central Police Station. That is not in doubt. It can also not be left to doubt that Central Police Station is the scene of crime according to the investigating officer. It is also not indubitable that the respondent is a senior ranking officer in the National Police Service in the rank of the Chief Inspector of Police. It is also not in dispute that the majority of the witnesses, according to the investigating officer, will be police officers who at the time of the commission of the offense were serving under the command of the respondent. Corollary, the respondent will significant influence and or camaraderie with the said witnesses with the likelihood of contacting them, thereby jeopardizing investigation entirely. It is also not controverted that the scene of crime was tampered with, where the CCTV surveillance system installed at the station were interfered with. Cumulatively, having laid down the evidence pointing to the possibility of respondents interfering with the witnesses and investigation, I can sagaciously adjure that the state has credibly and specifically demonstrated the likelihood of such interference. The fears of the applicant that the presence of respondents is likely to have on witnesses is not far-fetched and contrived, based on the Blue Code of Silence, which the Court of Appeal in the case of Titus Gamao Musila Katitu Supra ascribed is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. The said court went further to demonstrate incidences where police in Kenya have engaged in practice of covering up for each other. The respondent having served the police service for donkey years, approximately 29 years, it is ineluctable that he has created the network and the bond with fellow police officers who are likely to cover up for their own by deliberately tampering with the evidence, records, and loss of vital documents. This was demonstrated in the instant case where the DVR power cable was disconnected and the DVR logs changed and formatted. The foregoing argument finds parapet in the decision of R versus Police Constable Samson Muriu Kimbiu, 206 EKR, Inspector of Police Veronica, another cited case, Inspector of Police Veronica Gitai and another versus Republic 2017 EKLR, and Republic versus Mombi, a criminal case number 33 of 2020, which are some of the example of cases where the superior courts have unequivocally expressed concern over police cover-up of crime involving police officers. In the same breath, the IPOA Board end-term report May 2020 to May 2018 at page 93 enumerates the following facts, and I quote: in addition, non-cooperation by the service had been concerted efforts by officers to cover up crimes, with official documents and exhibits being tampered with, shoddy and hasty investigation by police to defeat justice, charging in court of victims of police misconduct to circumvent IPOA investigation, skewed interpretation of applicable law to justify police action, poor record keeping and failure to maintain proper record as per the law or maintain proper record as per the law or service standing orders, deliberate records tampering and loss of vital documents, manipulation of arms and ammunition movement register, and serialized and unsealed documents to circumvent justice cause. End of quote. I am therefore satisfied that the prosecution have placed before this court compelling reason to enable me deny the respondent his right to bail or bond at this stage. The investigating officer, Abdirahman Jibril, estimated that they are 49% through with the investigation. Extrapolating from that figure, I direct that the respondent shall be remanded for a period of 15 days to allow the conclusion of investigation.
Much obliged, Your Honor, and on behalf of the defense team,